Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Welcome back to the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today marks episode 28. We thank you again for joining us. This week, we will cover cases decided between December 30th, 2020 and January 5th, 2021. Up first is the case of Commonwealth versus McConnell. This case addresses the charge of disorderly conduct and the balancing act between disorderly conduct and protected free speech. This case began as a neighbor dispute between the defendant and his backyard neighbor. His neighbor had a swimming pool with string lights and a motion sensor security light in his backyard. The defendant was apparently disturbed by those lights. The defendant then obtained 8 construction-grade lights and directed them into his neighbor's backyard at 9 p.m. The lights were so bright that 9 neighbors called in to complain about the lights within 15 minutes of them being turned on. The defendant refused to turn them off even after police arrived. The lights were on for about 2 hours. The defendant was ultimately charged with disorderly conduct. He was convicted at trial and the case was appealed. An individual commits the crime of disorderly conduct if, with the intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, he creates a hazardous or physically offensive condition by any act which serves no legitimate purpose of the actor. While physically offensive condition is not explicitly defined, the court finds that the blindingly bright lights which disturb the entire neighborhood fit the bill. The defendant argues that he cannot be convicted of disorderly conduct because his lights served the legitimate purpose of protesting the lack of a lighting ordinance in his neighborhood. Because there was no ordinance, the defendant was disturbed by his neighbor's lights. The court had defined legitimate purpose as conduct which is lawfully and constitutionally protected. However, one cannot avoid the liability for disorderly conduct simply by claiming lawful purpose. The rights must be exercised in a reasonable manner. In this case, the defendant claims that it is his First Amendment right to protest. When a protected First Amendment right to free speech is implicated, a disorderly conduct conviction will only stand when the actor intends to breach the public peace by exercising his right in an unreasonable manner. In this case, the court finds that the record is clear. The defendant intended to breach the public peace by casting an unreasonable amount of light in his neighborhood. He then persisted in keeping the floodlights lit even after being advised of the disturbance that he was causing. For that reason, the court concluded that his exercise of his right was unreasonable and therefore not a legitimate purpose for using his floodlights. He was entitled to no relief. In 1987, the defendant in Commonwealth v. Moose participated in the rape and murder of a woman in York County. In 1995, he entered a negotiated plea, and pursuant to the terms of the plea agreement, he was sentenced to a term of 15 to 30 years incarceration. In 1995, there were no laws or requirements for sexual offender registration, and no registration requirements were included in his sentence. In 2011, SORNA was enacted by the legislature, and this defendant was informed that he was now considered a Tier 3 offender, which would be subject to lifetime registration requirements. In 2014, the defendant filed a pro se motion asking the court to enforce his negotiated plea agreement and enjoin any requirement that he register as a sex offender. The trial court denied his motion. He then appealed to the Superior Court, where the opinion of the trial court was affirmed. He then petitioned for allowance of appeal to the Pennsylvania Supreme Court. Some procedural background is necessary to understand the posture of this case, so it's important to note that in 2017, the Pennsylvania Supreme Court decided the Muniz case, which found that SORNA's registration requirements were punitive in nature and therefore violated ex post facto principles who applied to individuals like defendant committed an offense before the effective date of SORNA 1. In light of the Muniz opinion, the Supreme Court granted the defendant's motion and remanded the case to be reconsidered in light of Muniz. Meanwhile, SORNA 2 took effect. SORNA 2 divided registrants into 2 distinct subchapters depending on when the offense was committed. In 2020, the Pennsylvania Supreme Court decided the Lacombe case. The Lacombe case stood for 2 important principles. First, that the petitioner is not required to challenge his sex offender registration status within the confines of the PCRA, and second, that subchapter I is non-punitive and does not violate ex post facto laws. Subchapter I registration includes cases that occur between 1996 but before 2012, or were required to register under former registration law and their registration requirements had not yet expired. In reviewing this case, the court, after finding that Lacombe is dispositive that this case need not be addressed in the PCRA, considers the effect of his plea bargain on his obligation to register as a sex offender. The law regarding plea bargains is well established. Plea bargaining is not some adjunct to the criminal justice system. It is the criminal justice system. Accordingly, it is critical that plea agreements are enforced to avoid any possible perversion of the plea bargaining system. In reviewing all the case law, the court holds that a defendant's negotiated guilty plea precludes a subsequent application of a punitive registration scheme because it would effectively alter the defendant's agreed-upon sentence. This is so even where a negotiated plea agreement is silent regarding sex offender registration. Moreover, where a defendant pleads guilty in exchange for a specific sentence, he is entitled to the benefit of that bargain. However, when a registration scheme is not punitive, it constitutes a collateral consequence of a guilty plea. Because non-punitive registration requirements are not criminal punishment, they would not materially alter a negotiated term establishing a defendant's criminal sentence. The court finds that the application of SORNA 1 is a punitive sanction and therefore cannot be enforced against the defendant. However, the trial court has not addressed defendant's claims against SORNA 2, and therefore the case is remanded to determine if he would be required to register under SORNA 2. That's it for this week. Thank you again for joining us. As always, the full text of each case addressed, as well as several other cases that were not covered in this week's podcast, can be found in the case notes.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.